So hello and welcome. Today we will talk about one of the most important article of the Constitution, and that is Article 142. So Article 142 confers unique power on the Supreme Court to do complete justice between the parties when when the law may not provide remedy. Right? So इसका मतलब ये है कि Supreme Court can give judgment on any case where there is no law or where there is injustice. So Supreme Court can utilize power under Article 142 to do complete justice between the parties. So there are several cases where a law is not clear on what to do about the condition, and there are several cases where law is inadequate, right? So that time Supreme Court can use power under Article 142, and this power is very unique because Supreme Court has substantial power to use its discretion. So it's a discretionary power to do complete justice among the parties. So remember, so we will see where have been this power used. So first of all, protecting Taj Mahal from the yellowing. So this case is called as famous Taj Trapezium Zone case, TTZ case, in 1986 between MC Mehta and Union. MC Mehta was a lawyer and environmentalist. So Taj Mahal was yellowing due to the sulfur dioxide and because of the polluting environment near Taj Mahal. So Supreme Court gave order under Article 142 that between the area around Taj Mahal, around 10,000 square kilometer area around Taj Mahal should be pollution free, and the industries in this location should be relocated, right? So this was the case which Supreme Court used power under Article 142, and this article had a lot of impact on the industries around the Taj Mahal area, right, affecting the employment and the employment prospect of the people there and the livelihood prospect of the people there. Next case was releasing under trials. So there were under trials who already crossed, suppose the case was not ending, right, with respect to these under trials, and these people were still suffering in the jail, and suppose they were in the jail even after their maximum punishment for the case has been passed. So Supreme Court took the case under itself and released those under trials who already have finished maximum punishment under their case. The next is Bhopal tragedy in 1984, where Union Carbide factory, right, that factory, many due to release of toxic gas, methyl isocyanide, many people died in that area. So Supreme Court found that the existing law is not enough to do justice to the victims of the Union Carbide tragedy, and the compensation provided under the existing law is not enough. So Supreme Court under its discretionary power awarded around $450 million of the compensation to the victims of the tragedy, right? So remember this. So these are the cases where Article 142 has been used as a tool to do complete justice. But there is a criticism about this article, that this article is has used as overreach and has crossed the limits of judicial scrutiny, because we can say that in the 2014 Supreme Court cancelled coal blocks which it saw were not properly followed the procedure, right? And cancelling the coal block in 2014 seen as a judicial overreach because it affected many industries, it affected the many people, right? So that was the one case. Again, the banning liquor for sale on 500-meter range of the highways. So there was already law that banned sale of liquor on highways, but Supreme Court went further and put a limit of 500 meter around the highways. So this affected the liquor industry, also the people working in the hotels, right? And the whole infrastructure had to bring down because of this judgment. Also, Supreme Court issued direction to the states to implement this direction, guidelines given by the Supreme Court. So this was considered as one of the judicial overreach case against the transferring of Babri case when it was nearing to end, and transferred Babri case from Raebareli to Lucknow, right? So that was also considered as a judicial overreach. So what is the issue here? So issue is, many commentators say that the article gave Supreme Court sweeping power, because to do complete justice is a vague definition, is a vague term, right? So, and because of this, Supreme Court has been bestowed a lot of power which can be used in any case. Again, some criticize that the cases under Article 142 handled by two judge bench, right, which can sometimes give judgments which are unreasonable. So in order to make judgment reasonable, there should be at least 5 judge bench. Remember this. You can use this in mains, right? So this is again judicial overreach. As I said, the Supreme Court is crossing its boundary between separation of judiciary and separation of judiciary from the separation of executive, right? So breaching the boundaries of executive and judiciary separation under Article 50, right? So this was the case. Now remember, so there were certain cases, right? So under Supreme Court versus Bar Association of India, Supreme Court said that this Article 142 could be used to supplant the existing law, but only to supplement law. So इसका मतलब है कि you can supplement the law. So your judgment can supplement the law, but it cannot be used to override the law. So that was the meaning of this article. Again, the doctrine also says that there should be boundaries of separation of power. Again, in Premchand Garg case, Supreme Court said that the law must be consistent with the fundamental right, and the law must be consistent with the substantial provisions of existing laws. So Supreme Court twice said that the Article 142 cannot be used sparingly but reasonably to supplement the law and constitutional provisions, to supplement the law, existing law by Parliament and constitutional provisions. So it's not absolute power, but it has a reasonable restrictions, right? So recent there was a case that Supreme Court said that 5 judge bench Constitutional Supreme Court said that the court can grant divorce directly under Article 142, right? So usual case is that we transfer the case to marriage court, right, family courts, and and family court decides upon this case. But Supreme Court said that under Article 142 the court can directly grant divorce to the couple when it finds that the marriage will not work up, right? So this was about Article 142, which gives a sweeping power to the Supreme Court, gives a lot of discretionary power to Supreme Court. So from that perspective, this article becomes very important. So revise this article one more time. If you find any confusion, feel free to write in comment box, right? So that was all about Article 142. Thank you.